number 39, Chavez versus Occidental Chemical Corporation. Counsel?
May it please the Court, Your Honor, may I remain seated?
You may, sir.
Thank you. Ken Manning from Phillips Lytle, Your Honor, arguing today on behalf of Occidental Chemical Corporation, the appellant. I'm arguing on the briefs previously submitted by Vincent and Elkins. There are two certified questions. While they're of first impression to this Court, there are prior decisions of this Court that we think guide the Court toward a direction. In particular, the Court's decision in the King case and the Snyder case laid out the rules. At the time this case in Texas was first begun in 1993, Judge Kaye, speaking for a unanimous court, indicated that time limitations created by statute, and here we have a statute, CPR 213, the 3-year statute of limitations, are not told in the absence of statutory authority, and that courts may not themselves create such exceptions. Judge Simons, 3 years later in 93, the year this case was commenced, said that the court has been reluctant to modify the law concerning limitations, even when a party's case seems particularly compelling.
Counsel, do you recognize that many of our appellate division courts have recognized tolling domestically or within the state courts? Do you recognize that?
Yes, Your Honor.
Okay, and are you suggesting that we should overrule those cases now?
Well, this Court, Your Honor, has not been presented with an intra-jurisdictional tolling case yet, to my knowledge.
Okay,
and,
so then...
And that's...
Go ahead.
If I may finish, Your Honor, thank you.
Yes, of course.
So that's actually been assumed, it seems to me, in the Second Circuit's decision, but hasn't been presented to this Court. What's being asked today is to do something completely different.
Well, that's really my question, is it that different? So if we recognize it intra-jurisdictionally, why don't the same underlying principles for doing that apply cross-jurisdictionally?
If I may, Your Honor, first of all, within a system, for example, when this first started with American Pipe, there were cases within the system, the same court system, the same types of claims, and it was a matter of judicial efficiency and economy whether to let the individual cases sit while the class action proceeded. Here, it's quite different. A citizen in, whether it be in New York or some other state, is relying on someone in a completely different jurisdiction under a different set of laws, different set of facts, different set of pleadings, different code of evidence.
But what doesn't it have the same effect? In other
No.
words, the defendant gets notice by virtue of that other class action, and it enables that class action to truly serve as a representative action for those who are present and those who are absent. And it minimizes the number of placeholder actions that have to be filed. Why aren't all those things consistent domestically and cross-jurisdictionally?
Well, the key point, Your Honor, is that by doing this cross-jurisdictionally, New York would be yielding the control of the litigation and what happens in that litigation to either other states or, in this case, to foreign countries. This case presents the prototypical example of why cross-jurisdictional tolling can't work.
But the federal court is not a state court anyway. You're already ceding, under the way you approach it, you're already ceding to the federal court as it is.
Well,
in the intra-jurisdiction, you're already doing that.
In this case, Your Honor, what is happening in this case, if this court should apply cross-jurisdictional tolling here, the New York courts would be ceding jurisdiction not just to the federal court, but through the return jurisdiction clause, we'd be placing control over the effective statute of limitations in the hands of the litigants and foreign nationals.
Well, that's assuming that the return jurisdiction clause prevents the tolling from ending.
Well, Your Honor, first of all, if we recognize in New York and this court adopts a cross-jurisdictional tolling, first of all, it would depend on whatever happens in that other jurisdiction, unless this court should craft a rule for jurisdiction by jurisdiction. And in fact, what the legislature has done in Article 2 is craft an entire section with very carefully drawn limitations periods for particular claims and very particular tolling provisions. And this court in the past has, in its wisdom, deferred to the legislature to create tolling provisions that match the needs. In these records, for example, there's a lot of dispute over what the impact of cross-jurisdictional tolling would be, both on the minority jurisdictions who've adopted it and the majority of jurisdictions who haven't. All that information could be developed very carefully rather than on a single record missing information like you have here. And I suggest that the legislature could determine, first of all, what type of tolling should be involved, what the particulars of it should be, for example, how it should mesh with...
They could, but if they don't, that doesn't necessarily prohibit the court from doing so, which seems to be the position you're taking. But I still don't really fully, I think, appreciate your argument about the seating, because that's always occurs when a statute of limitations is told because of a filing in another court. You're always ceding to that other court.
Well, in this particular case, Your Honor, we're in the situation because if you adopt cross-jurisdictional tolling here, there's actually no effective statute of limitations at all. Right now, but for the fact that the coast...
Doesn't that really depend on how you answer the second certified question? I mean, I think that was partially the point that was being made by Judge Stein. You know, if you adopt a bright line rule in that second certified question, and there's a dismissal, for example, like there was here on forum nonconvenience grounds, that ends it. The toll ends, and you know, plaintiffs can file if they're still within the time.
Well, but to your point, Your Honor, how the end of the toll is designed is also something that typically a legislature can enact. A good example is 205. It's on the books now. It's been on the books for a long time. There, the legislature has suggested that in New York, for a New York resident in a New York case, you get 6 months after the commencement and termination of the first action within which you can bring your second action. If this court adopts cross-jurisdictional tolling, you'll be treating foreign nationals, citizens of other states, far better than you're treating someone who brought a case in New York.
Yeah, but Mr. Manning, let's assume we're going to adopt cross-jurisdictional tolling for the purposes of my question, and go to the second question. The Second Circuit there's some case law from the Second and the Fourth Circuit that talks about an application of a standard which they refer to as objectively reasonable to make a determination as to whether or not a merits or a non-merits dismissal of a class certification would terminate the class action tolling. Where are you on that?
Our answer is very simple, Your Honor. We contend that any determination, any dismissal of the action, or any denial of class certification for any reason.
So for any reason, any procedural reason at all, you would say that you've lost your right to go forward?
Yes, Your Honor, and here's why. Because the fundamental nature of class actions, either under Rule 23 in federal court or Article 9 in state court, is the obligation of the class representative to protect the interest of the absent class members. If the motion for certification is denied for any reason, that obligation ceases. Similarly, if the action is dismissed for any reason, that obligation ceases, and the absent class members have no reasonable basis for relying on the named representative.
Let me give you an example, and tell me what you think about this. Court dismisses a putative class action for failure to state a cause of action, but gives express permission to replead within 30 days. Would that be a dismissal?
That's a dismissal, Your Honor.
I see.
But that dismissal doesn't
excuse
happen
me.
until the 30 days has elapsed.
Well, that's not what he's saying. That's not what I hear what he's saying, Judge.
Well, I want to be clear about that.
Is that what you're saying?
But that takes us back to the first point, Your Honor, which is...
We need you to stay on this point.
No,
right?
I am on this point, Your Honor, if I may. It depends on how the judge words that order and how it's being handled.
Well, it's pretty straightforward. You get to replead in 30 days. Are you saying that that's an outright dismissal or not?
Of that case, Your Honor, I guess having reflected on it at that stage of the litigation, no, that would not be an outright dismissal.
All right, I accept that. That's a reasonable response. The reason I ask this is because there are procedural postures that can be taken that just as the example I just used, which be a procedural dismissal, but really, in practical terms, aren't a dismissal, and a bright line rule might not apply. And that's why I'm asking you about the objectively reasonable standard that the Second Circuit has applied and the Fourth Circuit has applied.
And so how does the return jurisdiction provision affect your last answer, if it does?
Well, on the return jurisdiction answer, it actually depends on how you interpret the return jurisdiction clause. How we interpret it is the same as the Eastern District of Louisiana, and that is on the return jurisdiction clause. We contend that was not written to, and in fact did not protect the rights of absent class members as written. However, we understand that both the state of Delaware and the lower court in this case has read into it, although it's not in the order itself, protections for the absent class members. But this whole conversation and argument, if I may, points to the issue of all the issues that a legislature in enacting a statute would consider in dealing with the situation.
You know, I paid attention to the legislative argument, and it's an argument that's used every time in every state. I think there are 9 states that have had this issue come before them, and they've split 4 in favor of cross-jurisdictional tolling and 5 against. And the legislative argument comes up each time. As I recall, in the original class, the Congress itself never actually ruled on this issue or legislated on this issue originally. Is that correct?
I believe that to be so, Your Honor.
Yeah. So you see my difficulty with it.
Well, I do, Your Honor. I see I'm out of time. I thank you, Your Honor.
Chief Judge she's a softie on
Listening
these
carefully,
things.
and you have your 2 minutes of rebuttal, sir.
Thank you.
Counsel?
And may it please the court, is it permitted for me to sit as well?
Yes, sir.
Thank you, Your Honor. Good morning. My name is Jonathan Massey, representing the respondents in this case. I'll start on the first issue, but I also want to address the second issue as well. The first issue, I think the legislative argument, Your Honor's questions illuminate the weakness in it. The cross-jurisdictional tolling, we think, is animated by the same policies and the same concerns as intra-jurisdictional tolling.
Well, on that note, 2 things. One, each state that's looked at this, and I think Virginia comes to mind, looks at their own statutory scheme to determine, can we do this? And I think Virginia said no. But we have rules in Article 2 of the CPLR saying we can't extend statute of limitations, which makes us a slightly different jurisdiction. And 2, with respect to the interstate tolling, to me, the federal rule here seems more like an intrastate toll, where there are federal courts applying a federal question and there's a different proceeding and they apply this toll. I've only found 2 cases where a federal court was looking at a state court action and determining whether or not they would give a cross-jurisdictional toll to the state. They're both out of the 7th Circuit. And what they really looked at there, and they came to 2 different decisions based on the claims that were made in the state court action. And it seems to me that's a good way of looking at, one way, the very different concerns that an interjurisdictional toll would raise. Because the federal system, where it's a federal question here and they're all playing by the same rules. They're playing by the same claims. And we're not. So do you think if we were to do this, should we limit it in any way related to the claims that are brought in the different state?
Well, Your Honor, I think certainly it is limited to the same plaintiffs and the same claims. It's a transaction and occurrence kind of thing. Here, I think the claims are all essentially negligence claims, and so the subject matter, the allegations are all identical in the different states. But let me also
And should that
respond.
be part of our test if we adopt cross-jurisdictional tolling?
Yes, I do think that you should limit it to claims that fall within the same transaction or occurrence. They wouldn't be broader than that, and it has to be the same plaintiffs, like as in the
What if there was an additional element required in the individual claim?
Well, I think that's still part of the same. There's a established transaction or occurrence test that you wouldn't have to reinvent. It covers res judicata and many other principles, and I think you could just adopt that here. But and so I don't think you would need to write on a clean slate. The New York situation, I think, is different, but maybe for a separate reason, which is New York has been a leader in class action tolling. It adopted it in Brinkerhoff in 1885, so a century before. And then in the Sutton Carpet Cleaners case, which was in 1947, the Supreme Court treated it as settled, and this court affirmed. Then when the legislature, I think the legislature has left this issue very clearly to the courts, because then in 1975, when the legislature greatly expanded the role of class actions under Article 9, it did not disturb this principle at all. And you might think, well, how could the legislature have been thinking about that in 1975? American Pipe was the year before. It was 1974. So this issue of class action tolling was actually, I think, in a very real sense, something that the legislature could have addressed, but did not, because it left it to the courts, which is consistent with the way the federal system treats it in every state.
Can I ask you about the period of time during which the Costa Rican plaintiffs are litigating in Costa Rica? Is it your position is your position, I assume, that period of time is told?
Yes.
And is it told because of the action of the federal court or because of the pendency of the similar claims in Costa Rica?
I think it's told because of the federal court, because Judge Lake retained jurisdiction, and he said that the return jurisdiction clause said that the claims would be reinstated
if instead the court had simply dismissed on forum non-grounds without a return jurisdiction provision and the Costa Rican plaintiffs immediately went to Costa Rica, you're not arguing that the pendency of the Costa Rican action as a class action told anything here?
We're not having to make that argument here. If the facts were different, a different set of plaintiffs might be, if there were no return jurisdiction clause, it might be different. But I think...
Well, so why?
Well, because this return jurisdiction clause...
Why would we pay attention to the federal court's order and not dependency in a foreign country?
Well, you very well might. I'm not trying to disagree on the Costa Rican point. It could be that
no, I'm trying to probe the analytical consistency between intra and inter-jurisdictional tolling.
I see. I think that essentially when you have a federal court, and when Judge Lake said, I will retain jurisdiction, and the case, if you reinstate it, will be reinstated as though it had never been dismissed, and that occurred against the backdrop of the plaintiffs predicting to him that there was a doctrine of preemptive jurisdiction in Latin America. And so 5 months later, that's only the gap in this case was only 5 months between the October dismissal and their return to Judge Lake, the plaintiffs' return to Judge Lake asking
That's the Costa Rican plaintiffs, and there's plenty in the record about them. The present complaint involves also Ecuadorian and Panamanian.
That is true.
What happened there? Where is that in the record?
Well, what happened was Judge Lake, the case had no geographic subclasses, and so there was no reason for any other plaintiffs. He didn't draw it up that way. And he said, Judge Lake, when the defendants made this argument back in Texas in 2010, they said only the Costa Rican plaintiffs have applied for reinstatement, nobody else. Judge Lake said, take that up with the Texas state courts. They did, and they lost. So the Texas state courts reinstated the cases as putative class actions, as they'd always been captioned. So the defendants had the opportunity to make this argument, and they didn't prevail. And so we think, frankly, that the court should take the Texas rulings on their face, reinstating the class action. They also take Judge Lake's orders on their face. He understood what he meant, and he said, when the case came back, he said this was a direct continuation of the prior action. So that's why I think the 30 days example on question 2, I think is very problematic for the defendants. Because if they say, as Betances against Fisher, the Bozzio Second Department appellate case from 2019, and the Scott against D.C. case. All of those involve dismissals for mootness or dismissal with leave to replead. If you are going to concede that those cases do not interrupt tolling because they are not definitive and they don't provide the kind of objective, they don't meet the objective reasonableness standard, or they're not even meeting the bright line standard, whatever rationale, also applies when you have a 5-month delay. In this case, when the plaintiffs had told
Counsel,
Judge Lake.
What if we disagree with that proposition? Because if we were to assume, and as I understand it, I think both parties here agree to the, is continued reliance objectively reasonable, or is it reasonable? And the more assumptions that go on, the more contingencies that are involved, it seems to me it's less and less reasonable. So if here, even with the return jurisdiction clause, you've got the named plaintiffs only, right, who are litigating in Costa Rica. And you have to assume that when they lose in Costa Rica, they're going to want to come back here and pursue jurisdiction back here, as opposed to possibly settling the case, which is what many of them did, maybe all of them eventually. You have to assume that the federal court would again remand to the state court. You have to assume that the state court would accept a reinstatement as a class action with the interveners rather than the named plaintiffs, and on and on and on. So how is that reasonable reliance, even with the return jurisdiction clause that existed here?
Because the plaintiffs told the Judge Lake that's exactly what was going to happen. They said, we are going to be back, and because the Latin American courts will not accept jurisdiction under this preemptive jurisdiction doctrine. And
well, that's what they believed would happen, but...
That's what their brief said to Judge Lake. And so that was, everybody sort of, on the plaintiff's side, everybody said, that's what's going to happen.
And you talk about it being 5 months here, but if that's the rule, that all of this stuff can be going on, it could be 5 years, it could be 10 years.
Well, I think that the reason to have the rules that we favor is that will incentivize the defendants to avoid delaying tactics. I mean, the reason for all these gaps and delays were that they acted within their rights. This was not sanctionable conduct that they engaged in. That's kind of our point. If it were sanctionable conduct, you wouldn't need these rules.
Again,
but,
you assume that it's, we're just looking at this case. But if we're making a rule, it could be a country where it takes years for anything to get through the court system.
Well, to make a rule, I would use just the objective reasonableness standard.
That's the standard that I'm suggesting.
Yes.
How are all of these contingencies, how do they make it objectively reasonable to sit back and wait to see what happens? Isn't that people sitting on their rights?
I mean, really the gap is at the beginning, the 5-month delay. I don't think, then the people knew they were going to be back in a punitive class action before Judge Lake. The idea that then it would be remanded is, I think...
The point is that when it went to Costa Rica, nobody knew whether it would be 5 days, 5 months, 5 years.
Well...
So, there has to be, it seems to me, for reasonable reliance, there has to be some cutoff point at which, okay, this is what's going to happen next.
That might be so, Your Honor, but I think if 30 days is in it, if you have leave to replead within 30 days, I think 5 months is in it.
But I thought your point wasn't really that. I mean, I understand that 5 months seems to tilt in your favor, but as you can see, as Judge Stein correctly points out, the rule is going beyond your case, right? So in other cases, maybe much more time. But I thought the essence of your point was that the reliance is, if you can't proceed in that court, you get to come back here.
Yes.
And then I'm going to rule on this. And that's what they're relying on.
That's
now, whether or
correct.
not it's 5 days, 5 months, 5 years, 20 years.
That is correct, Your Honor. I mean, I do think that...
I had thought
So then
that-
my follow-up question to that is, if that's your point, how does whether it's your analysis or case law support that's what the reasonable reliance is, that's what you're focused on?
Well,
This opportunity to return, right?
Right. I mean, that's what the Delaware Supreme Court and Judge Engelmeyer, I think, canvassed the record and went through all of the facts. I think, for example, here the express reservation of jurisdiction by Judge Lake, the language be reinstated so it's never been dismissed, the fact that the Texas courts...
So it's the anticipation of these putative class members that they have an opportunity to get back into a U.S. court.
Yes, it's a reasonableness, objective test,
Yes,
obviously.
yes.
And
Well,
yes.
Isn't the core analysis behind your test, I think, is enhanced by the questions that Judge Stein was asking, because she pointed to a series of circumstances that are unknowable and that happen in the course of litigation and makes each each case that comes before the court individual in its own merits and creates these procedural scenarios that we could never predict. And it seems we have one of two ways to go. Either we can say, you have to look at each case and say what's reasonable in this circumstance, given this procedural posture, or we have another way to go, say, this is the line, you're done, and no matter what it is. So if we said you could replead in 30 days and you were done in 15 days, boom, you're out. Those seem to be our only kind of options here. Is that a fair characterization of that?
Yes, I think that's right. I think the defendants have argued for a very strong, bright line, and our position is that the objective reasonableness test that's been in the Second Circuit. And I do think our test is better because it mirrors the policies behind American Pipe. I mean, Judge Laval said in the WorldCom Securities case, this is not a gotcha test. The idea is to encourage absent class members to rely on the pendency of a class action. That's how you achieve the efficiency benefits that the whole class action tolling rule is designed to achieve. That's why the Third Circuit said it's not the job of class members to look through the glass darkly. The Delaware Supreme Court had the same kind of language, because if you have a bright line test and you tell people any dismissal or question about the case should lead you to file placeholder actions, then New York and Delaware and New Jersey are all going to be hit with additional cases because they are the home turf for many corporations. So plaintiffs worried about personal jurisdiction will come to those kinds of states. So I think it's telling that New Jersey and Delaware have both adopted class action tolling.
Thank you, counsel. Counsel?
Yes, first, Your Honor, may I suggest that New York, through the Brinkerhoff case, did not establish cross-jurisdictional tolling. It was an intervention case under the Field Code, and even before the class action statute was enacted, and I don't think it particularly provides guidance in this matter. To Judge Stein's point about what the absent class members, an objective class member, would be thinking at the time, we haven't talked at all about the trip to Hawaii for another class action during the pendency of this. How could an absent class member be relying on Texas for an independent class action brought in Hawaii? That was among the variety of things that we contend make the absent class members' reliance upon the class members in Texas unreasonable. The Costa Rican plaintiffs, when they came back to Judge Lake, they came back with their own claims. They didn't protect the absent class members. They dealt for their own claims at that point. That's because the return jurisdiction clause was directed only to the plaintiffs and not to the absent class members. You can look at the lengthy period of time, some of which were court delays, some of which were precipitated by plaintiffs, and some of which were precipitated by defendants. But you wind up with this case 27 years later at the pleading stage in New York because the plaintiffs advocate for 27 years of tolling for a case that would have been brought and tried in New York decades ago.
Except throughout that whole process, you knew the nature of the claims, you're in control of all of what has gone on in your companies, right, in your clients. They know the nature of the claims. They know what, in many ways, what their exposure is. And that's really, I think, what makes the argument so weak, in addition to much else that goes on. You really are on notice. You understand. And that the whole point of, or one of the points of statute of limitations is to make sure that the defendant has some notice and you don't have stale claims and all that.
Well, if I may, Your Honor, some notice is the key word. There's 16,000 plaintiffs, we think. We haven't heard from the other 24 companies. The other 24 countries haven't come back to Judge Lake. So what do we know about those claims? What do we know about those people? Now, Judge, in the Eastern District of Louisiana, the trial judge there
Isn't it the companies made a poisonous product that injured lots of people?
The company has denied that, Your Honor.
Sure. But you're aware that obviously there's more nuance to that.
Yes, of
take
course.
it seriously in that way. But you know the heart and soul of these claims.
Well,
And as he's already conceded, should there be filings in the state court that involve some other elements of claims that really could not have been perceived, they don't arise out of the same occurrences or transactions, then you might have grounds to say that tolling cannot apply to those kinds of claims.
Well, if we were all in one system, Your Honor, I would agree with what you're saying, but we're not. We're in a completely different system. And I think it's objectively unreasonable for an absent class member to have relied upon what was going on in Texas during the 27 years.
Thank you, counsel.
Thank you.
Thank you.